Greetings of the day. This is Dr. B. Rajesh Kumar. I'm Assistant Professor, Department of Management Studies, Madanapalle Institute of Technology and Science. Today we will discuss about the meaning of intellectual property rights and what are the different types of intellectual property rights. Why intellectual property right is very, very important. These three objectives we will discuss today. Coming to the what is the intellectual property. Before going to the intellectual property, let us see what is the meaning of property. Usually, we are using the term property means asset or value. Here, property we divided into three categories. Number one, personal property. Number two, real property. Number three, intellectual property. Property means simply value or monetary value or asset. Property can be classified into three categories. Number one, personal property. Number two, real property. Number three, intellectual property. Personal property is a property which arises from your parental people or parental organizations or your father or some ex. So that is known as personal property. Suppose your father is having 1 crore rupees. With the help of 50 lakh rupees, he purchased one gold item. Suppose he gives that gold items to you. That's not your property. That is your father's property. That father's property is known as personal property. Suppose your sister is having 50,000 rupees. On behalf of 50,000 rupees, with the help of 10,000 rupees, she has given one gift item to you. That gift item is known as personal property. That means personal property is an asset. Personal property is a value which arises from your parental, which arises from your seniors, which arises from others. That is known as personal. It's not a great to you. If they are having so much money, if they are having so much amount, if they are able to give to you, that is your personal property. Coming to the real property, it is completely belongs to land or agriculture. Suppose today I purchased 1 acre of land in front of RK Beach area in Visakhapatnam. I have a right to sell that product to someone with more than 10 crore rupees because that much of value is there opposite of RK Beach area now. That is known as real property. Suppose I have 1 acre of land in front of MITS college. That 1 acre of land is known as a real property to me. Suppose I'm a person who is doing all the businesses which is related to real estate. Because I'm dealing all land activities, I can say proudly I'm a part of the real property person. That means indirectly real property which is completely belongs to your land. Coming to the third one, intellectual property. Intellectual property is a property which arises from your intellectual activity. Intellectual property is a property which arises from your talent. That is known as it is intellectual property. Shall I repeat you once again? Intellectual property is a property which comes from your talent. Intellectual property is a property which arises from your talent. So that is why this is an intellectual property. Coming to the point number two, why intellectual property rights are very, very important. Suppose I have created some knowledge for myself. That knowledge exactly 100% belongs to me only. You people, you don't have any right to copy that knowledge without consent from me. That is why we are using intellectual property. That means intellectual property is a legal right which is granted by government to offers to creator or inventor. Shall I give an example to you? Suppose I have created one machine. The knowledge, the talent, the hard work, the sincerity, the passion, whatever I offered for that machine, it is completely belongs to my knowledge only. It is completely belongs to my talent only. If someone uses to my machine, definitely they have to take the permission from me. Without taking the permission from me, according to intellectual property rights, I have a right to make a case against on him. That's why we are using intellectual property. Because that property belongs to myself. That property belongs to me. So that is why intellectual property is always a legal property which arises from your talent. That means whatever I have created the knowledge, whatever I have verified the knowledge, it is completely 100% belongs to me only. Let us see how many types of intellectual property rights are there. So, what is the right of each and every category? Now we will discuss it. Intellectual property rights generally we have divided into there are so many parts. Number one, copyrighted. Number two, patent. Number three, trademark. Number four, trade secret. Number five, geographical indication. Number six, industrial design. Shall I repeat you once again? Number one, copyright. Number two, patent. Number three, trademark. Number four, trade secret. Number five, geographical indicator. Number six, industrial design. These six categories are belongs to intellectual property rights. Coming to the first one, copyright. Copyright is a legal right which is granted by government to offers that right to original creator, original author, for the purpose of performing, displaying of his original work. Shall I repeat it once again? Copyright is a legal right which is granted by government that offers to creator, that offers to original author for the purpose of performing, displaying of his original work. That means indirectly, if I want to copy anything from others, definitely we have to take the permission from original other like that. So that is why it's a copyright. Means all authorship works belongs to copyrighted. That means copyright is a legal right protects to all authorship works. Suppose all literacy works. Literacy works means textbooks, journals, magazines, seminars, speeches. These all are the categories of literacy works. According to copyrighted law 1957, if I wanna copy any copied thing, definitely I have to take the permission from original person. Come to the second one, musical works. All musical composing things are copyrighted. That means indirectly, if I want to copy any charanam, if I want to take copied any pallavi from that song, I have to take the permission from original musical composer. Without taking the permission from him, I don't have any chance to copy it from others. If I will copy the things from him, according to copyrighted law, he or she has a right to make a case against on me. Come to the third one, dramatic works. All dramas, all stage performances, all are copyrighted. That means if I wanna copy any drama, I have to take the permission from original author. Coming to the fourth one, photographs, all are copyrighted. Coming to the fifth one, pictures, all pictures are copyrighted. These five categories are belongs to copyrighted. If I want to copy anything, I have to take the permission from original author. Coming to the patent, patent is a legal right which is granted by government that offers to creator for the purpose of his or her invention. Authorship works are belongs to copyrighted, whereas process and inventions are belongs to patent. Are you getting my point? Something differences between copyrighted and patent. All authorship works are belongs to copyrighted, whereas inventions or methods are belongs to patent. Copyrighted is a legal right which is protects to original author, whereas a patent which is a legal right protects to inventor or creator. Suppose if I introduced one machine, I have a right to apply for a patent. Suppose if I introduced one method or process, I have a right to apply for a patent. Suppose if I introduced one agricultural variety, I have a right to apply for a patent. Because there are so many patents are there, approximately we have so many, but according to patent law 1970, we have three types of patents. Number one, utility patent. Number two, plant patent. Number three, design patent. Utility patent relates to all methods, all innovations, all processes belongs to utility patent. Design means all aesthetic appearance conditions, all are the category of design. All agricultural varieties are belongs to plant patents. These are the different types of patents are there. Copyrighted protection period life plus 60 years. That means as a other, if I created one copyrighted in the year of 2020 until 2080, I have a right to copy that content with myself. No one copied from me until 2080 because now 2020 plus 60 years means 2080. If I will die in 2020. because life plus 60 years. Suppose I applied for a copyrighted in the year of 2015. 2015 plus 60 years equals to 2075. Until 2075, I have a right to perform my copyrighted content. If someone copied my content, definitely they have to take the permission from me. Patent, we have protection period exactly 20 years, not approximately, exactly 20 years from invention. Suppose I got it a patent right in the year of 2020, I have a right until 2040 to sell my invention, to use my invention, to compose my invention. If someone used my invention, they have to take the permission from me. If they won't take the permission from me, I have a right to make a case against on him in court. They will be penalized. After 20 years, it is completely common product. Come to the third intellectual property, trademark. Trademark is a logo, symbol, quotation, mark, which is identified goods and services from competitor. See our college quotation different, or another college quotation is different. That quotation also belongs to trademark because it's a logo, symbol, which identified the goods and services from competitors. That logo and symbol also our talent only. Usually, trademarks are categorically divided into four categories. Number one, product trademark. Number two, service trademark. Number three, collective trademark. Number four, quality trademarks or certified trademarks. Product trademarks we are able to see with the naked eye, like Horlicks. See the quotation. Whereas service trademark, it is belongs to all services only. Certified trademarks, which are related to identification of quality only. Collective trademarks, which are used for identification of entire organization only. One logo, one symbol, one quotation, whatever it may be. That logo, that symbol, that quotation, which are completely belongs to my knowledge only. If someone will copy my logo, my quotation, definitely they have to take the permission from me. Otherwise, according to Trademark Law 1999, I have a right to make a case against on me in a court. That is a impacted trademark. Coming to the fourth one, trade secret. It is known as completely confidential information. When I do job in my organization, whatever the revealing that information, definitely I have to take the permission from my employer. Without consent from my employer, if I reveal that total information to someone, according to Trade Secret Law 1997, employer has a right to make a case against on me. That is impact of trade secret. See, the meaning is there on that word only. Trade, which is related to business. Secret means it should be confidential. Trade secret, it is a confidential information. That means, as an employee, you shouldn't disclose your company information to others. If you want to disclose your information to others, you have to take the permission from employer. That's why we have non-disclosure agreement. We have confidential information agreements are there. Before going to the job, before going to the any organization, you check it. What is the rules and regulations in confidential agreement? If you are violated that agreement, you have to be penalized. You have to repay your salary to your organization. That is why when you do some agreement, you take care on what are the contents, what are the rules are there. Coming to the five geographical indicator, GI tag. GI tag is a product which identifies your character, which identifies your product of condition, which is exactly related to your location. The best example, tea, which is belongs to Darjeeling tea. It is one geographical indicator, legalized intellectual property. That means I don't have any right to sell the Darjeeling tea in Madanapalle. If I want to do like that, they have a right to make a case against on me because GI tag is there. Darjeeling tea. There are so many products are now they're waiting for geographical indication tag. They are doing something. We are waiting for the better results from Indian government. If GI tag is there, product is automatically globalizedly recognized. Come to the sixth one, industrial design. It is a part of patent, but it seems to be like one aesthetic design. Design also one intellectual property. That means if I want to copy any design from others, I have a right to make a case against on him because already I created one intellectual property for industrial design. But the last thing is that these all are the intellectual property rights. Government has given some protection period for that one. Copyright, life plus 60 years. That means on the time, if anyone will copy it without consent from the original author, they have a right to make a case against on you. Protection period equals to life plus 60. Patent 20 years. Trademark 10 years. Of course, trademark we have renewal process. Trade secret, it is not a protection period because it's a confidential that belongs to your inner discipline. Geographical indicator, we have 10 years. Industrial design, we have 10 years. This is the protection period for all intellectual property rights. Why protection period is very very important? Because with the help of protection period only, if I want to take any copied thing from others or original creators, these laws must be useful for him. if these laws are if these laws all are not there, all contents are public domain, everyone can use that original talent. That means indirectly creator will lose his credibility. That's why IPR system is there in Indian government. IPR system and IPR law is always protects to creator, inventor for his original work. This is a basic intellectual property rights. Thank you. Thank you so much.